Welcome to the Law in Context podcast.
I'm Emeritus Professor Stephen Bottomley, former Dean of Law at the Australian National University in Canberra.
And I'm Emeritus Professor Stephen Parker, former Dean of Law at Monash University in Melbourne.
Between us, we have written books and articles on corporations law, lawyers' ethics, family law and many other legal topics.
In most episodes, we take a legal topic of interest, perhaps one that's in the news, and relate it back to fundamental questions about the legal system.
So whether you are a member of the public wanting to know more about law and make sense of what is in the news, or you are studying legal studies, criminology, or even a law degree, our plan is to help you with a deeper understanding of what is going on. So far, in these Law in Context podcasts, we've often referred to the common law. The adversarial system, the role of the judge and jury, and the ethics of lawyers all take their shape and content from the common law. But what actually is it?
As we'll see, it's confusing enough anyway, but there are three separate meanings. First, the common law is a kind of legal system with its own form of reasoning. In this way, we distinguish common law systems from civil law systems. Second, within such a system, the common law is contrasted with something called equity. So a common law system contains both the common law and the law of equity. And third, lawyers talk about common law to contrast it with statute law, such as Acts of Parliament. The common law is case law made by judges and not statutes made by parliamentarians. So, in this masterclass of how to lose an audience, even in the introduction to a podcast, let's go through these three different meanings in a little more detail.
First, the common law as a system of law applies in many countries which were colonised by England and then decided to keep it or receive it after gaining independence. About 1/3 of the world's population lives in a common law system, or a hybrid one, where the common law is a dominant influence.
Reasonably pure versions are found in England and Wales, Australia, New Zealand, the USA and Canada. But even in the US, Louisiana is not a common law state because of its French colonial origins, and that's also true in the Canadian province of Quebec. I studied law about 100 miles from the Scottish border and learned nothing about Scottish law at all, which is a hybrid jurisdiction. For centuries, it had operated on Roman law principles, and it was not until the Act of Union with England in 1707 that common law approaches began to enter there.
The common law as a system began after the Norman invasion of England in 1066. Henry II, in about 1154, brought it all together so that the same law was common across the country and applied in all of the king's courts. A famous English jurist in the 1700s, William Blackstone, argued that common law was derived from the customs of the people that had existed since antiquity. The law, he said, was pre-existing, and the judge's role was to divine it. This is the declaratory theory of common law. The answers are all in there somewhere, but the judge needs to find them.
Finding out the law in a common law system, especially on a topic where there is little or no statute, is actually very complex, and this possibly adds to the sense of craft mysticism that the initiated have particular skills and knowledge not available to outsiders, which of course reinforces the central role of lawyers in the system.
Essentially, the common lawyer tries to find the rule that applies to the current situation by looking at previous cases, precedents, and then argues that the rule applies to their case if it suits them, or should be distinguished from their case if it doesn't.
But to find the rule, you have to look at the reasoning in those previous cases. The nugget you are looking for in a previous decision is its rationale, usually known as its ratio decidendi, the reason for deciding.
Extracting a ratio decidendi can be like pulling teeth. You might slog through 3 or more very long judgments in a single case, with each judge wanting to say it their own way, only to find that all 3 reach the same decision, but by different routes, leaving the ratio decidendi still unclear. You're listening to the Law in Context podcast by the two Steves.
Remember to rate us on the platform you are using.
Now, back to one of us.
Even when you think you've extracted the central rule from a previous case, you then have to work out whether that rule is binding in your situation now.
The doctrine of precedent essentially means that decisions of superior courts, such as final and other courts of appeal, are binding on lower courts in that jurisdiction. But if you don't live in that jurisdiction, you might be just over a state border, for example, the decision will be influential rather than binding. But how influential you won't know until you try it out in court.
All this is quite different in civil law systems, such as in France, Germany, Scandinavia and Switzerland, and the countries that have adopted their approach. Their codes are intended to be comprehensive. Each judge interprets the code and applies it to the case in front of them, but the decision of one judge is not usually binding on another judge. In theory, they all start interpreting afresh.
The common law is built upwards from the ratio decidendi of numerous cases. The civil law is applied downwards from the code. Common law reasoning is inductive and civil law reason is deductive. We'll evaluate the two shortly, but let's quickly describe the second and third meanings of common law that we outlined at the beginning.
The common law can be contrasted with something called equity. We're devoting the next episode to equity, but let's say for now that equity began in a court presided over by the Lord Chancellor, who was the keeper of the King's seal, rather than a court of common law, which was nominally under the King himself. Equity developed to bind people's conscience and to knock the hard edges off common law rules. It's still alive and kicking today, as we'll see, although common law rules and equitable principles are now applied in the same courts as different thought systems, with equity usually prevailing.
The third meaning of common law is in contrast with statute law. As we saw in episode 3, a statute prevails over case law, assuming the statute is constitutionally valid. More and more, statutes in common law systems do attempt to codify the whole law on a subject, or to replace outmoded aspects of the common law with rules more suited to the contemporary world. In parts of Australia, for example, this is the case in criminal law. But even here, the courts interpret these codes, and the common law method gets cracking again.
And to make your head spin a bit further, a court, such as the High Court of Australia or the Supreme Court of the United States, might find a statute unconstitutional and strike it down. And they might use earlier cases to come to that conclusion.
Well, Steve, this is all very interesting, or not, but a reasonable question is why in this day and age of widespread literacy, searchable databases of all court decisions and all statutes, and increasingly with artificial intelligence and computer-based reasoning systems suggesting answers, why do we persist with the common law approach? Why not finally codify everything and be done with it?
Well, maybe this is slowly happening with the expansion of statute law. In our episode on the adversarial system, we ended with the lame conclusion that it seems to fit some kinds of societies and the inquisitorial system seems to fit other kinds. You could say the same about the common law and civil law.
One surprising claim is that the common law is actually more predictable than civil law. Over the centuries, so many cases have been decided by the most senior courts, covering thousands of different situations and binding on lower courts, that although you do have to dig a bit to get the answer that comes out of the other end is a predictable one. In civil law, it may be easy to find which code provision applies to a particular situation, but you might have no idea how the judge will interpret or apply the code.
Some economists argue that it is the common law that led to most innovation in property rights and contracts, leading to the earlier rise of England and the United States as commercial nations. As the hidden hand of the market pushed people to find the most efficient and advantageous solution, this argument goes, they in turn pushed and prodded the common law with novel arguments, not held back by an all-encompassing code.
A sleeper issue in the whole of the world's law is what you might call the relevance of consequences. In the common law, occasionally a superior court is faced with a choice and thinks about the consequences of one choice versus the other. By and large, the law is applied irrespective of its consequences, and it's up to Parliament to legislate if it doesn't like it. consequences probably creep into the reasoning of judges more in civil law systems.
However, we can glimpse a future where algorithms draw on huge databases and can generate detailed predictions of the consequences of one rule versus an alternative rule on the economy or public safety or health, whatever the case may be.
This will make courts confront a philosophical question about justice. Is it something essentially about following correct procedure, such as applying a common law precedent blindly, or is it about outcomes?
And of course, we looked at this in episode 10 on what is justice.
So, Steve, are you trying to fool the listener into thinking that this podcast series is all planned as a coherent whole?
No, I'm a common lawyer. I just pile one thing on top of another and see where it takes us. Thank you for listening to this episode. You can find more episodes in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Over time, we will build up resources on the website with further exciting reading on the topics we've discussed.
We're the two Steves, and that was a Law in Context podcast.
As the two Ronnies used to say,
it's goodbye from me.
And it's goodbye from him.
Bye.
Well, thanks for researching all this history, but didn't you forget to mention the code about the Knights Templar?
That was the Da Vinci Code. It was fiction, you dumbo.
No need to be common, Steve.